You want some rebuttal time?
Yes, Your Honor, I'd like to reserve 5 minutes.
You got it.
And may it please the court. So this appeal is an appeal of an order granting a motion to vacate a previously filed notice of voluntary dismissal. The court had entered an order directing the parties to be prepared to discuss the court's jurisdiction and whether the order on appeal was.
Why don't we start with that?
Excuse me, Your Honor?
Why don't we start?
Yeah, absolutely, Your Honor. So the appeal was filed pursuant to Rule 9.130A5. The provision there says orders entered on an authorized and timely motion for relief from judgment are reviewable by this method provided by the rule. Committee notes go on to say subdivision A5 grants a right of relief for review on orders on motions seeking relief from a previous court order on the grounds of mistake, satisfaction, judgment, or other grounds listed in the rule. Rule 1.540. So the order on appeal was an order granting a motion filed pursuant to Rule 1.540.
Right, you're likening the text of 9130A5, the motion for relief from judgment, to me. What it really meant was a 1.540 motion. Basically what you're saying.
That's correct, Your Honor. But here's the thing, and there was motion practice directed towards this specific issue. The court did deny the motion. And so the previous argument was, hey, this is not judgment and this is not final order. This is a Rule 1.5 for a motion directed to a notary dismissal. Not a judge. I can appreciate this.
What we have, if we just go back to the text of the rule, not follow the the text of the rule said a motion. That's not what got here. This was a motion that granted an order granting a motion sets out a voluntary dismissal. Particularly, the concern I think that we have here is we had a case outside air conditioning at 6/7/26. Where we noted in that case, look, an order involves does not neatly fall within the composition.
So Your Honor, I think there's two things. First, I'll point to also the court had the Cottrell case, which was the 188 Southern 3rd 88, and 9.130 of a order granting pursuant to 1.540, an order granting a motion for relief from a notice of voluntary dismissal. Precisely what's in front of this morning. So when we take a look at the Cottrell case, there's no distinction between what Cottrell does in this case. And then I would also go back and say, look, the law is settled that a Rule 1.540 is the vehicle by which you can seek relief from a notice of voluntary dismissal.
That's clear.
Absolutely. But the law is also settled that you can't file a 1.540 motion directed towards a non-final order. So the issue is a notice of voluntary dismissal.
The Pino v. New York case, though, wasn't that precipitated upon a 1.540 motion? And if your argument was correct, then the court would have had a much shorter opinion when it just said, no, you can't use this vehicle to review this.
Well, what they said in there is there's got to be some vehicle by which motion is that a notice of voluntary dismissal immediately divests the court's of jurisdiction, no different than if you're finding whether it's or an order of involuntary dismissal or final judgment. It is a termination to a degree. It's likened to a final judgment, and like I said, Your Honor, this court in Cottrell treated it exactly like that, and so that's how we proceeded.
Yeah, I'm not sure that addresses our other prior case where we converted it to a writ of prohibition, which would be a very different argument, very different substantive argument we'd have to make. Here, if you're in a position of having to argue a writ of prohibition rather than abuse.
Absolutely, Your Honor, and don't perceive this as being a non-final, non-appealable order. I looking at the Cottrell case, which is what we rely on, with the position that this was an appealable order. Turning to this, August 18th of 2021, the Cho responds almost immediately thereafter with a motion to dismiss. About 3 weeks after filing the complaint, Pipeline then files a notice of voluntary dismissal. Several months later, in that same year, Pipeline files an unsworn motion to take the voluntary dismissal that gets denied. They get permission to file again. They file a second motion to vacate the voluntary dismissal. This time supported by the opposes the motion, saying that set forth the elements needed to demonstrate a mistake. They go to a hearing, at which point they produce testimony. And what's important here is that he testifies it had to be a mistake, but then when he's he concedes that he does what led to the signing of the notice of voluntary dismissal.
To take him at face value, I take him at his word, just conclude that it was a mistake, or just judge the proof that it was a mistake.
Sure, the 540 is a discretion, but we then go on to say the case, which basically says, look, the court still has to receive substantial evidence before it can exercise. The attorney comes in and says, it was a mistake. That's all I have to say.
Is there any cross-examination?
There was, briefly, I'll just go through the Q&A. It says, so at the time of the dismissal, did you review the file, correct? I think I did, obviously not very well. Question, so did you review the file and we did make the determination at that point, when you reviewed the file, that the notice of voluntary was properly signed at that point in time? Answer, absolutely not. I did not make a determination. I apparently signed it either without looking at the file carefully, machine the file, or, maybe I was past. I don't specifically remember. I have a lot of cases, and sometimes, I conceivably we're looking at the wrong. I don't recall what happened here. All I know is that this was a monumental error. And so what he concedes there is that he doesn't have a specific recollection. He specifically asks, as a matter of fact, you don't have a specific recollection, and he says no. And so at that point in time, we make the argument that there is no competent substantial evidence. The court grants the motion, and its appeal follows. And so the issue before this court, assuming the court has jurisdiction, is whether or not the testimony of, I know it was a mistake, but I don't really recall what happened, is competent substantial evidence of mistake. Now, on appeal, our position is the burden is on the movement under the 1.540 standard to demonstrate evidence of mistake.
But the thing that I'm thinking is, even if they said whatever they want to say, that you would be satisfied that's substantial evidence, the trial court said, I don't believe it. They still could, they could have denied it, but they could have granted it if there was more evidence or less evidence. So you have this situation where there's less evidence, what you think is appropriate. The judge grants the motion to set aside take on face value without getting into a can of worms, which is the big malpractice potential. So if you lose the motion and they say it's malpractice, you have a problem, doesn't it? So the judge grants the motion.
The judge grants the motion. I think, from a standpoint of whether or not there is a competent substantial evidence, I think that's the issue.
I get all that. I just, I'm kind of like sympathetic to all sides here.
How does one prove an inadvertent mistake then, in your formulation? I'm curious.
Sure. Well,
and put that to put an ornament on that.
Mhm.
How do you align whatever that view is with? It's not exactly thinking about it, it's the same subdivision, which is default cases. basically opened it up all over the place. You know, there was a breakdown in all the procedures, good enough to get you out of the default.
Sure, you're right. I would just say that there is a slight distinction because a default is usually non-action. It's inaction. Okay, and that's really where the Cottrell case, again, going back to that case, does offer that illumination here, because what the Cottrell case deals with is a circumstance where there's a notice of voluntary dismissal filed. And the reason why it's filed is initially the attorney or the plaintiff is informed that the statute of limitations had expired. So they go ahead and they file a notice of voluntary dismissal. They later found out that the statute of limitations might have been told and to vacate it. And the court says, well, you made that decision. It was a mistake, but not the type of mistake that falls within the ambit.
It's a strategy.
It was a strategy mistake. Oh, correct, Your Honor. And so pure mistake, it has to be something, you have to demonstrate that it was something that falls within the ambit of Rule 1.540. So
Which case law says encompasses human foibles, which is what I think was Mr. Singer testified. It was like, this is just a breakdown, you know, it was an error.
well, what he says is, I don't specifically remember, but it must have been an error. And I think that's really where the rub is sure, he could come in and he could say, I was looking at the wrong file and I signed this. But what he says is, I don't specifically.
So your formulation the rule, then it's not enough to say there was a mistake, there's also a mistake. You need to positively identify what exactly the error was in the procedure in order to be entitled to any kind of relief in 1.5 based on mistake. Is that a rule you want us to announce?
No, Your Honor. I think that you just have to demonstrate competent substantial evidence of mistake. You don't have to be.
What you're really asking is how did it break down and how did the attorney make a mistake? That's what you're really asking for. You want the full explanation.
Well, Your Honor, I think there again, going back to the Cottrell case, where that case says, look, not every mistake, in that particular case, they try to couch it as a mistake, and it was a strategic decision, and maybe it was wrong in the end, but they try to couch it as a mistake, and of course, if that's not enough.
What do you see in this case that could be a strategic decision?
Well, Your Honor, the record is largely devoid of the reasons behind it, but what you do have is they file their complaint, there's a motion to dismiss, and then shortly thereafter, there's a notice of voluntary dismissal. Whatever reasons behind the filing of the notice of voluntary dismissal, they're really not before the court, because the specific.
Doesn't that distinguish this from Cottrell?
Well, Your Honor, assuming there is a benefit of the doubt component to it, then yeah, I would agree that, well, all things being equal, we're going to give benefit of the doubt to vacating the notice of voluntary dismissal. But that really turns the burden on its head, then, because then what ends up happening is anybody who's opposing the 1.540 motion, that person has to disprove. And I don't think the burden is on the non-moving part.
Or was there a statute of limitations expiration?
In this particular case, I don't believe so.
Yeah, literally the only two filings that preceded the voluntary dismissal were the complaint and then
The motion.
to dismiss, which, as I recall, was really just challenging the sufficiency of whether or not the elements were there.
Correct, Your Honor.
Okay, you got 6 minutes left. You want to keep?
I'll reserve the remainder, Your Honor. It's relatively simple. Yeah.
Thank you. Thank you. Get all the answers?
Morning, Your Honor. Today, please the court, Jonathan Hempling, Marquez Singer, for Pipeline. And just real briefly, I know, Judge Lucas, you touched on it. Our motion to dismiss the appeal was just based on the plain language of the appellate rule that states any non-final order that's appealed has got to be delineated within those rules, and this particular circumstance is not within that rule. That was the basis for the motion.
Was your motion denied?
It was.
Judge Powell. So here we are again, and we've looked at it, we want more argument now. And you're saying it should have been great, you're basically saying it should have been great the first time.
Right, I really don't have anything else to add, and I know, opposing has touched on Cottrell actually dealing with similar circumstances. I'll stipulate that it certainly does. And it doesn't discuss jurisdiction anywhere, in my opinion. I even went to the briefs to try to find, and it's just not there. So I can't explain it, but if we go by the rules,
Well, let's talk on the substance of his argument. Was there abuse of discretion here, and was competent substantial evidence provided or not provided?
sure, Judge, I don't believe there's abuse of discretion here. I think, number one, the motion states a colorable claim for relief on its
No,
face.
facts, though.
I'm sorry.
It states a culpable claim for relief under the rule, but the facts are scarce, correct?
I would disagree that the facts are scarce. There was a mistake made, and I think I can provide a little bit more detail that wasn't touched on. When it comes down to the breakdown in operating procedure, not only was this testified to at the hearing, but it's within the motion, is that when the motion to dismiss came in, the procedure is to note the file, motion to dismiss received. And instead, as stated, it was noted to draft a voluntary dismissal. That was done and put in front of Mr. Singer, and he signed it. So I think the testimony that's reflected in the transcript in regards to Mr. Singer's testimony that he doesn't recall is not directed as how this was done, but why in fact he signed it, which I think, in all candor, he just said, I don't remember.
Is there anything on the face of the record that would foreclose the possibility that this was a strategy decision to begin with? I know it was like a statute of limitations would have expired had you not reinstated the case. That's obviously non-abuse of discretion, let's say. Court can go either way.
Right, there's total absence of any indication that this would have been tackled.
All right, I got you.
So I think the motion in and of itself with the accompanying affidavit states a colorable claim for relief, not only in the type of mistake that was made, but it also shows the plaintiff counsel's intent on continuing the litigation. And that is in terms of post dismissal. We filed responses to we moved to mediate, and only then did we realize the mistake had been made, and then within the same day filed the initial motion, which was initially denied to that. So we believe that pretty conclusively establishes a claim for relief under 1.54. As to the court's question as to the evidence, I think there's 3 levels of evidence that the trial court could have used here and did use, and therefore abuse of discretion is not what happened. The first, of course, would be the affidavit that was filed and accompanies the motion stating clerical error on behalf of the clerk in drafting it and putting it in front of the attorney. The second thing is testimony at the hearing, which basically restates what's in the affidavit, and then upon cross-examination, really just kind of confesses, I don't know why I signed it, which is the subject of a large part of the brief. I'm sorry?
You've got a lot of cases.
Right.
A lot of clients.
Right, and I think the third part of the evidence, of course, is the court record itself. I mean, I think the judge looked at everything, and you can see that there's no intent to dismiss this case. While it was dismissed, that was not the intent of the attorneys, and it was not tactical, and therefore it kind of brings us out of a lot of the cases that are cited in Pelham's brief. So, as a result of really the motion itself stating a culpable claim for relief, competent evidence being addressed and shown to the trial court in the form of the affidavit of testimony and the subsequent filings, we believe that there was no abuse of discretion here and that the trial court's order should stand. And unless the panel has any questions, I'll sit down. Thank you very much.
Thank you. All right, you want 5 minutes?
I'll just very briefly,
You're right, there's 15 minutes, 5 minutes, you do the whole argument.
understood, but understood. I'll be very brief then. Yeah, just going back to the level of evidence that were there. I mean, there was an affidavit that was presented, which was very scant in statements. It was basically conclusory. Typically, you got to basically demonstrate more than just the conclusion.
Well, Mr. Singer did represent, I mean, he was never sworn in, but it doesn't seem like anybody objected to that. He did state to the court, look, the procedure in this case, would be an update the file to reflect that a motion to dismiss it in file, unfortunately due to clerical error, blah, blah, blah. They mark that file dismissal instead of a motion to dismiss receipt.
Right.
Why doesn't that satisfy the whatever bar you have in mind, to what specificity that needed to be there? That doesn't meet the bar or?
Your Honor, I think, you know, when he says, this is what happened, it's essentially what somebody else did. And then when he's asked, well, okay, you know, how do you know what happened? He goes, I don't know. This is just speculation. That's where it falls apart, Your Honor. That's basically our position. With that, we'll answer. Go ahead.
I want to congratulate you both, by the way. This would be a perfect example for a law school field procedure professor. This showed kids. All right, have a great day.
Thank you.
The next case is Miller and the agenda.